Good morning, is it Mr. Banyai?
Yes, it is, Your Honor. Good morning.
Good morning, and I'm assuming that we are still not going to have an appearance from DDC. No one has signed in, so we are prepared to hear your position in this case.
Yes, Your Honor. Thank you very much. Would the court prefer a factual recitation before I begin, or should I just dive into my arguments, Your Honors?
Whatever you're comfortable with. We've obviously read the briefs and have the records, so you can feel free to do a shortened version of the statement of case and facts if you like.
Yes, Your Honor. I think the essential dates are as follows, Your Honor. On June 15th, 2016, the respondent came into Lee County Legal Aid Society's offices and filled out an application to determine his eligibility for representation. On July 13th of 2016, he was sent some correspondence indicating that he had not met the guidelines that we had set forth at that time for acceptance of his case. On May 8th of 2017, the appellant petitioner applied similarly to the Lee County Legal Aid Society to determine her eligibility to receive representation.
Can I ask you a question on that one fact you just mentioned? Is there
Absolutely.
any indication in the record why the legal aid conflict system didn't catch that conflict at that point?
No, Your Honor. Unfortunately, I was not running Lee County Legal Aid Society at that time. I don't know exactly what the reasoning was in accepting that client, but
There is a system set in place, because clearly that was a conflict. You can't talk to one person and then take the other side later on, despite the fact you may have lost papers, may have been a flood, may have been a hurricane. All those factors don't excuse the conflict. There's still a conflict. In my mind, your biggest issue in your favor is the untimeliness of the motion to assert the conflict. Can you focus on that?
I absolutely can, Your Honor, and I do have some arguments that I hope the court will consider, that it even still, Judge, there was no consultation, and thus there's actually no, it doesn't apply, but I will move right on to that, Judge. I
don't mind talking about that. This issue centers around whether or not your client was a prospective client of legal aid at the time, not your client, but the client's opponent. I think the bar rules are pretty clear. If you go and talk to someone, you're a prospective client, whether they take your case or not.
Yes, Your Honor, and I think that as I will go further into the case, Your Honor, I will argue that there are independent bases, such as the timeliness argument, that Your Honors could find that it would be appropriate to quash the order of the trial court granting the appellee's motion.
Well, I'm trying to focus on the timeliness issue because I think that's your winner, and that's just my vote. That's just my thought, unless you talk me out of it.
I will try not to do that, Your Honor.
Well, the opponent says it is timely because he didn't know that he had the right to assert the conflict of interest until he bumped into a lawyer somewhere and said, oh, what about this? But that was 14 months after the fact, correct?
That it was actually more than 2 years after the fact, Your Honor.
Okay.
And in those 2 years, and I believe these facts will be relevant, there was not one, but two mediations that occurred, one of which resulted in a mediated agreement. There was a motion for drug testing, which was granted. And then the case was set for trial, and that trial, the or tennis motion made just prior to opening, Your Honor, by the appellee, was over 2 years later. And I think that when I begin talking about Rahman v. Jackson, that will become extremely relevant, Your Honor.
I think the other side says a pro se litigant should have more slack, more leeway in asserting timeliness under these circumstances. And if so, is that discretionary with the trial court who bought the magistrate's recommendation?
Well, I think we'll see in Strawcutter, Your Honor, that there is an actual inquiry into whether there is actually a conflict and whether there is actually information that could be used to prejudice the opposing party. And that should have been part of the inquiry into whether this was a tactical maneuver.
Well, are you talking about the affidavit? Because the affidavit was gone. By the time of this hearing, a new affidavit had been filed. The one that legal aid took hold of was missing. I don't mean the storm and so forth.
Your Honor, I don't know whether the court will find this distinction significant, but it wasn't an affidavit. It was just a piece of paper that someone handed to a receptionist.
Okay, it was
Yeah.
financial related though, right?
Yes, sir.
Okay, I'm sorry if I misspoke.
Not at all, Your Honor. I would briefly mention the standard of review only because, quite frankly, I think the standard of review case helps my position, and that's Straw Cutter v. Straw Cutter, Your Honor. And I mean, the standard of review, Your Honor, is a departure from the essential requirements of the law. But I think the language in Straw Cutter v. Straw Cutter, all of the things that they mentioned, that this is, resorted to sparingly. This is something that generally is viewed with skepticism by the court. That language, Your Honor, I think that indicates that if this is an on-the-line case, if this is an on-the-line situation, figuratively speaking, that erring on the side of caution, Your Honors, is not granting the motion to disqualify. Rather, erring on the side of caution is acknowledging the constitutionally protected right to choose counsel, and to actually, that erring on the side of caution in this case, Your Honor, would be quashing the trial court's order.
Well, one question is this: I don't see any cases on point where we have a pro se litigant move for disqualification. I know that this case went on from the filing of petition for a year and 3 months or a year and 4 months, and a few things happened at which, the purported father attended. But can we impute that type of knowledge? Because moving to disqualify is not really a common thing that a pro se is going to know. Now, maybe procedure is, but that's really not a common issue that we would expect a pro se unsophisticated person to know, is it?
Probably not, Your Honor, but I do think that the reasons cited for the motion to disqualify should inform the court as to whether this is merely a tactical maneuver for the purpose of disqualifying counsel on the other side, or whether it is a genuine concern. And I think Straw Cutter makes very clear that that is an inquiry that the court should engage in. So I
think that the magistrate may have placed some undue weight on his statements about contacting other lawyers, but that was simply, he called a lawyer's office and they said, I can't talk to you because I talked to the mother. And then when he got to court, he told the magistrate that he had spoken to a relative who was a criminal defense attorney who told him that he should raise this issue.
That's exactly right, Your Honor.
So, I mean, given that, I haven't made any conclusion on that either way. How does that support like a gotcha tactic?
Well, in one sense, Your Honor, if he has spoken to a law firm already, and that law firm already has told him prior to his conversation with his relative, I can't talk to you because there's a conflict, then at that point, he is on notice that that concept exists. And if he had a genuine concern at that point that, oh my gosh, something that I said in this application that I submitted could be used to prejudice my case, it should have been clear to him at that moment. And yet we're being told that it was actually a different conversation that he had later, where it was then brought to his attention by a relative that this was something he could do. And yet we're not really hearing the basis on that, or what the concern is. So I think that's what should indicate to the court, those two things, Your Honor, that there's this delay in time. He should have been even a pro se unsophisticated litigant. And I don't know what authority we distinguish between pro se litigants. I don't know where we would draw that authority from, Judge. But if we did, I think that the court should look to the time delay lag in between when he's first informed of the concept of conflict, very explicitly, apparently, by another law firm, and the fact that this is an or tennis motion raised the morning of trial, and it's supposedly because a relative told him to.
Well, the authority on timeliness is just the opposite. Isn't a pro se litigant held to the same standard as a represented litigant, absent some form of prejudice, and the other side was not able to establish prejudice in this case?
I would agree with that reasoning, Your Honor, and I think that supports the idea that it should be quashed.
Well, that goes back to my original question. Did the court in this case have some sort of discretion to overlook the timeliness factor? And if so, what would that have been based upon?
I think as Your Honor indicated, it seemed to have been based on his status as a pro se litigant being informed by a relative that he could do this. And I don't know from what authority that distinction can be drawn.
Okay, I got you.
So Your Honors, that is the standard review straw cutter. I think, again, makes clear that the court, if the court finds this to be a close, figuratively speaking, on the line case, it should fall in our direction, and the order ought to be quashed from the trial court. To get to timeliness, which I 100% concur is the strongest argument that I have to make. I believe I have a highly applicable case on point. That's Rahman v. Jackson, and that's cited in the motion. It's 992 Southern 2nd, 390 1st District, 2008. Your Honor, it's extremely short and brief, but it's shockingly similar in terms of the timeline that it cites as really what seems to be the relevant portion of its finding, and says that a period of over 2 years that transpired as the case was being litigated certainly contributed to what I believe is that court's conclusion that this was a tactical maneuver. And it's worth noting, Your Honors, that I think that the facts of Rahman v. Jackson set forth a fact pattern that is should give a court more concern about the potential for conflict of interest, where there are two different litigations running in tandem. One of them is a dissolution of marriage action, and that's the one that is excuse me, Your Honors, that I may be confusing straw cutter, but in any event, there are I believe I am, Your Honor. I beg your pardon. Straw cutter is the one with the two litigations running.
This is a paternity action.
Yes, Your Honor. However, I do think there is similarity in straw cutter. If I could back up a moment, Your Honor, and I think that the facts of straw cutter should give a court far more concern than the facts here. And yet, the straw cutter case falls on the side of allowing the person to keep their counsel. To go back, I'm sorry, Your Honors, to Rahman v. Jackson. I think the time period that is cited there is really the most significant fact in the sense that there's a 2-year period, and similar to the present situation, Your Honor, there's a tremendous amount of opportunity for the other side to at some point indicate that there should be a disqualification. They don't do that, and because of the length of time that had transpired with an active litigation, just as we found here, Your Honor, the Rahman v. Jackson court did eventually find that motion was untimely. I think that rationale stands independently of any of the other arguments that may be made. And I believe that it can and ought to be as simple as the application of Rahman v. Jackson, as well as straw cutter v. straw cutter.
Well, isn't Transmark just as good a case, because it's only a 10-month delay, and another first DCA case also found waiver. So you have more than one case in your favor.
Thank you, Your Honor.
I'm not making your argument.
Yes, Your Honor. Your Honor, I do think, again, it is simple as the straw cutter plus Rahman v. Jackson equals quashing the order. However, I have a few other arguments that I'd ask the court to consider as well. We can talk, I think, about the idea of a prospective client. And I would argue, Your Honors, that simply submitting a piece of paper in a lobby that has financial information at that time for the purpose of evaluating whether they meet financial guidelines for acceptance. I believe a consultation, Your Honor, consulting with an attorney, that language in the prospective client rule, the Florida Rules of Professional Conduct. I don't believe a consultation occurs where information is handed to a person. A consultation occurs when there is feedback, when there is advice, when there is a response to the substantive material that is submitted.
I'm not sure the law supports you on that, because if the client disclosed what would otherwise be confidential information, then the lawyer doesn't respond in any meaningful way, it doesn't mean that no confidential information has been shared, right?
Well, Your Honor, I agree with that. However, I believe that the Florida Rules of Professional Conduct apply to prospective client relationships, and I don't believe that the language of the rule encompasses the act of handing a piece of paper to a receptionist. And I think
the key point really whether or not, I mean, apart from the timeliness issue, isn't the key point whether or not there was actual sharing of any confidential information or the giving of legal advice, or both?
Well, I think that it is certainly possible, Your Honor, for there to be confidential information communicated in a piece of paper that is handed to a receptionist. But I do think that there is a practical consideration for the court to consider along those lines, in the sense that, currently there are tactical maneuvers where people can schedule consultations with as many lawyers as they have time and money for to sit down with. And if there's instead a system where someone just prints out 1,000 pieces of paper that say my name is and here's what I make, they run in and just hand it to the receptionist and just run out again.
The problem with that argument is handing in a piece of paper with the name and how much I make isn't likely to be confidential information because that should be discoverable. The real issue to me is whether this record supports any conclusion that actual confidential information was shared. And it seems to me one of your arguments in your brief was that there's no indication that it was truly confidential, material confidential information.
Well, and I believe, Your Honor, if Your Honor is indicating that in my factual hypothetical scenario of somebody tactically trying to establish conflicts, if that is not confidential information because it's information to which we're all otherwise entitled, then in that sense, Your Honor, I would agree with Your Honor's point. I do think that there is an issue of staleness to consider as well, Your Honor, that if we're given information 2 years before, there's really no, and by the way, Judge, it's unsworn, so there's no way for us to really prove even who it was that actually gave us that piece of paper. Now, I don't want to get too...
I know you're going back over the timeliness issue, which I think we have a really good handle on.
Yes, Your Honor.
On the confidentiality aspect, is there anything that you haven't argued that you'd like to make a point of?
No, Your Honor, other than the point that in the hearing before the honorable court just on the exceptions, Your Honor, at that point, the appellee did indicate that he said something about doing drugs to the receptionist, and that was his attempt to, I think, establish that there was a conflict. I don't think that that is credible, Your Honor. I don't think the idea that someone is in a lobby handing a piece of paper to determine financial eligibility says, hey, by the way, I do drugs. I think that that is, number one, a factual dispute, which will go to the procedural due process argument that I'm about to make. But it's quite frankly just not credible and seems to me to be a transparent attempt to establish.
But the trial court didn't make any findings on that.
I don't believe so.
The trial court didn't go there.
Well, no, Your Honor, but the trial court didn't hold an evidentiary hearing. So we don't, I mean, I don't know we really had an opportunity to flesh that out.
Well, is that really an issue? Because there was indeed a motion before the trial court for a drug evaluation.
Yes, Your Honor. And
so that was disclosed and that was out in the public.
Yes, Your
so
Honor.
I'm not sure that that remains confidential anymore. So I don't see that as an issue.
That's exactly right, Your Honor. And to kind of go back, and I know the court kind of wants me to move on from the issue of timeliness, but I think the separate issue of just the staleness is independent from the timeliness argument. And if we get an affidavit, excuse me, Your Honors, not an affidavit, a piece of paper from someone, we know really not who, but somebody saying I'm this person and here's how much I make. And then 2 years later, we get a sworn affidavit from somebody. I don't know how we would possibly use that information to impeach. I don't know how we would use that information, even if it were all true, because number one, it's out of date. And number two, it's unsworn. But in any event, Your Honor, I can sense the court wants me to move on to procedural due process, so I will do so. Your Honor, I do believe that there is a factual dispute that was established with regard to whether there is a prospective client relationship, and that does, I think, depend in some sense whether there is confidential information. I mean, Your Honors, the straw cutter court does care whether there is actually information. That is an inquiry they do engage in. And so it is relevant. Do we have information that we can use against this person?
Well, was procedural due process raised as an issue in the trial court?
It was, Your Honor. It was raised actually initially on the feet of the one of our staff attorneys.
Memorandum to the magistrate?
That as well, Your Honor. It was raised in the memorandum to the magistrate, but timeliness was raised in that memorandum, and procedural due process came out of our staff attorney's mouth on the spot, Your Honor.
But that was in relationship that the magistrate didn't hold a proper evidentiary hearing. It was a different type of due process argued, not the one you're arguing on appeal.
Well, I am arguing, Your Honor, that there ought to have been an evidentiary hearing that was conducted, and that was an argument that we raised in our memorandum of law submitted to the magistrate, that the magistrate had erred by not conducting an evidentiary hearing because there are facts in dispute, such as, did he say by the way, I do drugs, while he's standing in our lobby and handing that person a piece of paper. And that is one.
Got just about a minute left, so use your time accordingly.
Yes, Your Honor. For the procedural due process argument, Your Honor, we've cited to event firm v. Augustin, and I would argue that because there is a factual dispute, the trial court erred in not conducting a full evidentiary hearing. I believe that argument was preserved both by our staff attorney raising it on the spot, as well as in the memorandum of law that was subsequently submitted to the honorable magistrate prior to the magistrate's decision. So I guess sort of to summarize our arguments, Your Honor, we are asking this honorable court to quash the honorable court's order disqualifying us as counsel on the basis primarily, Your Honor, because it is untimely. Additionally, Your Honor, because there is no relevant authority to cite for a distinction made between a pro se litigant and an attorney. And they ought to be, in the absence of such authority, they ought to be held to the same standard as the litigants were held to in Straw Cutter.
Very good. I'm sure you could hear the bell go off, so that will conclude the argument. We appreciate your appearing, and we will move on to the next case. So thank you very much.
Thank you very much, Your Honors.
Thank you. Nice framework behind you.
The next case is Lee Memorial Health System versus Hildebrand.